We're going to start by looking at ethics rules and ethical philosophies. Now, you might think that ethics is not really an important subject for business law because maybe it's not law at all. It's just philosophical, ethical imperatives. But as it happens, a lot of our legal regimes come from certain ethical philosophies and positions, and so it's useful for you to know them in order to understand how our legal regimes have evolved. And the CLEP exam does in fact ask about areas of philosophy that are relevant to law. So we're going to take a look at some of the core philosophical positions first, and then we'll also talk a little bit about the particular ethics rules that involve attorneys. So first of all, with regard to theories of ethics, you could have what are called deontological theories. And the idea here is that these are ethical obligations that you have regardless of the consequences. You have them just because those are the principles of being human, those are the natural rules that should affect human beings, and the consequences are not the relevant issue. The question is, what is the right behavior? We have a picture here of John Locke, who is a well-known deontological thinker, and he focused on natural rights, that there are rights that we have because we are human, and they are rights to life and health and liberty. They are natural, they're intrinsic to humanity, they're universal, they're inalienable, and the Declaration of Independence famously was based on Locke's theory. So under Locke's approach, it wouldn't matter, for example, if you were killing one person to save another person. The killing of the one person would itself be wrong and unjustified, no matter why you were doing it. Another deontological theorist is Immanuel Kant, and he had this idea of the categorical imperative, which is a set of ethical obligations that all people have, regardless of their preferences, regardless of their consequences, and the core of it is that you always have to treat others as ends, not means. And again, the idea is you can't do something bad to someone as a means to a greater good, because the doing something bad to someone would then be treating them as a means to an end rather than an end in themselves. So both Kant and Locke had theories of right behavior that were independent of the consequences or the reasons or the preferences that you might have. Now, in contrast to that, Jeremy Bentham and John Stuart Mill, who are pictured here, put forth what are known as consequentialist theories, which focus on the impact of your action, not your motive, not what your imperative is as a human being for right action, but rather what is the actual impact in the world. They particularly put forward theories that have become known as utilitarianism. And the idea of utilitarianism is that an action is justified if it does the greatest good for the greatest number of people. And so it might actually do harm to some people if it does more good to more people. And so it's really very different from the deontological theories because it would allow you to harm one to save five, for example, whereas the deontological theories would not. Turning to legal ethics in particular, those are the rules that govern the conduct of attorneys, and every state has legal ethics rules. The American Bar Association put out model rules of professional conduct, and states have by and large adopted them sort of like uniform laws. But they all have, every state has its own variation and set of rules that lawyers have to follow. But the core is that lawyers always have a duty to act in the best interest of their clients, and they have to avoid conflicts of interest. And you could actually have a malpractice action against an attorney if they either behaved in a way that was improper or unethical, or they violated local ethics rules in any way that would be a basis for an action of malpractice against an attorney. So just so we understand some of these rules, and we're not really going to go into a great number of them, one of them really that I think business people need to understand and therefore is relevant to business law is the attorney-client privilege idea. And the idea here is that things that you tell your attorney when you are the client cannot be revealed absent the client's consent. And the idea here is to really privilege the idea, the giving over of information to a lawyer honestly and openly without having to worry that that lawyer is then going to testify against you at trial or something like that. The lawyer is sworn to keep that information secret. Now, in order for the attorney-client privilege to work, though, there has to be an attorney-client relationship formed. So you can't just go up to any attorney on the street and say confidential things to them. You actually have to hire them to be your attorney. And therefore, there has to be an attorney-client relationship. And also, the communications have to be intended to be confidential. They have to be delivered in a confidential setting. We don't want attorneys to have conflicts of interest. We don't want attorneys to be representing two different sides of the same issue or the same lawsuit, for example. So you can't obviously represent people who are on two sides of the same lawsuit, but you also can't represent two clients if representing one will push legal rules or legal arguments that would harm some other client in some other lawsuit. This is why, for example, it's very hard for attorneys who represent, let's say, corporations in employment discrimination lawsuits. They usually can't take on a plaintiff, an employee, in an employment discrimination lawsuit, because in the course of zealously representing the employee, they will almost inevitably advance positions that would be contrary to their client's interests in other cases. So you can't have a concurrent conflict. Now that can be waived if it's disclosed to the clients and they agree, but in general they don't. But you could also have a former conflict. So you can't represent a client in the same or a substantially similar matter if the client's interests are materially adverse to a former client, unless that former client consents in writing. And you also can't use the information from the former client in a way that's adverse to the interests of that former client. You have to essentially maintain your loyalty to that former client even after the attorney-client privilege and the attorney-client relationship is over. You also can't have separate business dealings with your client. So if your client is a corporation, you can represent that client, obviously, but you can't then also enter into a separate business relationship with that client where maybe you go into business together, or you do a joint venture together or something like that. You can't do that unless the terms are reasonable, the client has an opportunity to seek independent advice, and the client agrees in writing. So you can see exactly why we would have a rule like that. We don't want attorneys to use the relationship, the trusted relationship they're in, to start pushing business deals and other ancillary arrangements unless it's really an arm's length transaction where the client has time to get independent advice and make sure this is something that they really want to do. And any consent that the client gives to any of these, to waive any of these privileges, have to be informed consents, which means they not only have to be knowledgeable, but they have to be told about what the consequences of consenting to the attorney are likely to be, so that any decision that they make to waive any of these privileges or any of these rights will truly be with full knowledge of the consequences.